Good evening and thank you for joining us on BeeTv Major News at 6. Reaching you live from Benin City, the Edo State capital. I am Evelyn Izibili and now to the news in details. The People's Democratic Party and its 2024 governorship candidate, Dr. Aswe Ighodalo, on 17th of April 2025, filed an appeal to challenge the judgment of the Edo State Governorship Election Petition Tribunal that upheld the election of Senator Monday Okpebholo as the duly elected governor of Edo State. Senator Okpebholo and the APC have also filed their reply to the appeal by the PDP. In this special report, our senior reporter, Bess Orator, will highlight the prayers or otherwise of the petitioners and the respondents.
I want to thank God Almighty that made this possible. We also want to thank the good people of Edo who voted for us. This is not a news to us, because Edo people have spoken before. The court has just reaffirmed what Edo people voted for. So we want to thank God, we want to thank the people of Edo. And I also want to congratulate my principal, the executive governor of Edo State.
Monday Okpebholo is the governor of Edo State. He was elected by Edo people. And we are using this opportunity to call on everybody in the state to come together at this point.
This is victory for Edo people. This is victory for democracy. And we have confidence in the judiciary in delivering justice.
On Wednesday, 2nd of April 2025, the Edo State Governorship Election Petitions Tribunal dismissed the petition by the People's Democratic Party and its candidate, Dr. Aswe Ighodalo. The panel, headed by Justice Wilfred Kpochi, had said that the petitioners failed to prove the alleged overvoting and non-compliance to Electoral Act. It is based on that judgment that the appellant in this instance, that is the PDP and Aswe Ighodalo, have approached the Court of Appeal here in Abuja to challenge the outcome of the tribunal judgment. In this special report, our focus will be to highlight the prayers or otherwise of the application by the appellant and also the prayers of the respondents in this petition. So sit back and enjoy these special reports. The appellant, PDP, and Dr. Aswe Ighodalo are appealing the judgment of the tribunal on two grounds. The issue for determination is whether, having regards to the pleadings of the parties, the applicable laws, and judicial precedents, the tribunal was wrong when it rejected the oral and documentary evidence led by the appellants as proof of the facts of non-compliance with the provision of Section 73(2) and 51(2) of the Electoral Act 2022, and in holding that the appellant did not prove grounds 1 of the petition, and whether, having regards to the pleadings of parties, the quality of evidence led by appellants, and the state of the law as laid down by the Supreme Court, the tribunal was wrong that the appellant did not prove their case of collation of incorrect scores and exclusion of results of 96 polling units, and that the appellants did not prove ground 2 of the petition. And whether, having regards to the pleadings and upon proper evaluation of the evidence and the correct application of the law, if the tribunal was right when it dismissed the petition. Also, the case of the appellants is the issue of pre-recording in Form EC 25B as prescribed by the first respondent INEC for compliance with the provisions of Section 73(2) of the Electoral Act does not contain the serial numbers and other particulars of result sheets, ballot papers, beavers machines, and other sensitive electoral materials in 378 polling units. The appellant said the complete absence of the record in Forms EC 25B in 378 polling units was indicative of total non-compliance with Section 73. The PDP in the appeal said the Forms EC 25B not only manifestly showed that no serial number of any sensitive electoral material was entered in them, but claimed that it was also the case of the respondents through their cross-examination of appellant witnesses that the serial number of sensitive electoral materials was not entered into Forms EC 25B. According to the PDP and Aswe Ighodalo, the tribunal failed to appreciate that the Form EC 25B were the statutory records of compliance and non-compliance with the provisions of the law. It said the tribunal also failed to appreciate that the tendered exhibits were in themselves admissible in evidence in proof of whether there were prior recording in the forms prescribed by INEC of the quantity, serial numbers, and other particulars of results, ballot papers, and other sensitive electoral materials. Referencing the case of of Okoye versus Charles and others, the appellant said the tribunal was clearly wrong to hold that the oral evidence of the witnesses who were present at the polling units were necessary to prove non-compliance with Section 73, subsection 2 of the Electoral Act. They maintained that the certified true copies or original of INEC documents which manifestly disclosed non-compliance having been rendered as sufficient proof of non-compliance in Section 137 of the Electoral Act and an exception to the hearsay rule as codified by Section 38 of the Evidence Act 2011. On issue 2, the complaints of the appellants in Ground 2 are under 4 subheads, which are as follows: alleged collation of incorrect scores in 125 polling units, that the collated scores on Form EC8B not predicated on any of the Form EC8A in 10 polling units, collation of results on Form EC8B that are not derived from any Forms EC8A in 101 polling units, and the exclusion of results from 76 polling units of Ikubaka local government area. They claim that none of the respondents meant the appellant's case on Ground 2 in the evidence presented before the tribunal. They said the issues before the tribunal were whether there were collation of incorrect scores and exclusion of or failure to collate the results that duly emanated from the disputed polling units. The summary of the reason upon which the argument is founded and conclusion according to the PDP and Aswa Ighodalo is that 13,344 votes are liable to be deducted from the scores of the appellants as contained in the Form EC8D, and also claimed that 55,279 votes are liable to be deducted from the scores of the second and third respondents in Form EC8D. The PDP in the appeal said that the collation of correct and lawful scores of the parties using the certified true copies of Form EC8A uploaded to IREV shows that the correct and lawful scores of the appellants in 312 polling units under the grounds of the petition is 16,651, and the correct scores of the second and third respondents is 12,338, alleging that the correct and lawful votes is 243,113 for the appellants and 210,326 for the second and third respondents, indicating that the appellant won the election with a margin of 32,787. In reply to the appeal, the respondents urged the appeal court to dismiss the appeal of the PDP and Aswa Ighodalo for lacking in merits, and particularly because 1. that the tribunal duly considered the pleadings and properly evaluated the evidence adduced by parties before coming to the correct conclusion that the appellants failed to prove their petition against the respondents. 2. that the findings and conclusions of the tribunal are sound and proper, as clearly borne out by the evidence on record before the court. 3. that the appellants have not placed anything before the appeal court to suggest or show that the decision of the tribunal are erroneous or perverse in any way as to warrant the setting aside of the judgment. The respondent, Senator Monday Okpebholo, and the APC wants the appeal court to determine whether the tribunal was right when it arrived at the conclusion that the petitioners failed to prove substantial non-compliance as pleaded by the petitioners, such as to warrant the granting of the relief sought by the winner of the Edo State governorship election held on September 21, 2024. They also want the appeal court to resolve the issue for determination in the affirmative and to dismiss the appeal in its entirety as lacking in merit, and it is important for the court, according to them, to begin by pointing out that the ground 1 of the appellant's petition before the tribunal was predicated on the complaint of non-compliance with the provision of the Electoral Act. The respondents listed the following reasons why the appeal court should dismiss the application by the PDP and Dr. Aswa Ighodalo as follows. 1. that the documents tendered by the appellants from the bar to prove the alleged non-compliance were dumped on the tribunal and were of no evidential value, as the appellants did not call any competent witness to tender, demonstrate, and relay the document to the aspect of the appellant's case. 2. that the PW1 to PW14 of the appellants, not being polling unit agents and not being persons present where the polling unit booklets were filled, were strangers to the document who were incapable of giving direct eyewitness evidence to demonstrate and link them to the aspect of the appellant's case. 3. that the polling unit booklets tendered by the appellants were doubtful provenance that cannot be relied upon because they were incomplete, consisting of only 7 pages each instead of 9 pages, and there were no explanation for the missing 2 pages on each of them before the tribunal which the petitioners and the appellants failed to adduce. 4. That in the face of the doubt raised by the missing pages of the polling unit booklet, the appellants were duly bound to call polling unit agents or other persons who were present at the polling units and witnessed alleged non-compliance to adduce direct eyewitness evidence before the tribunal, which the appellants failed to do. 5. That the provisions of Section 137 of the Electoral Act 2022 does not avail the appellants the circumstances in this case and does not relieve the appellants of the burden of proving their petition to the satisfaction of the tribunal as required by law. 6. That the evidence of PW1 to PW14 is hearsay evidence and is of no moment since they were nowhere near the polling units during the election, and that even the 5 polling unit agents PW15 to PW19 called by the appellants did not say a word concerning the issue of non-prior recording of the serial numbers of election results, beavers machines, and other election materials which form the main complaint in ground 1 of the petition. 7. That the evidence elicited during the cross-examination of the PW2, PW3, PW4, PW7, PW8, and PW12 of the appellants negatives and contradicts the case set up by the appellants that there was no prior recording of electoral materials as prescribed by Section 73(2) of the Electoral Act 2022 before the election. Number 8. That the biomodel voter accreditation system beavers machine, which were tendered from the bar and were not activated or open for their content to be demonstrated before the tribunal, were of no avail to the appellant to prove the alleged overvoting. They said the tribunal in this case properly reviewed the pleas, evaluated the evidence, and correctly applied the law to the fact that they came to the right conclusions based on the existing and well-established precedents and authorities which is duly referred to. The respondent said the tribunal cannot be faulted for abiding and